all-time high, 53rd all-time high.
Lawrence County depends on WDXE News, on the air since 1951. This is The Legend. 105.3, 95.3, WDXE.
And it's Friday, which means it's Bulletproof Estate Planning time.
With estate plan, Stan.
With estate plan stay. And how are you, my friend?
I'm doing good. How about you?
You had a good week, I hope?
I had a very good week.
So,
how about you?
The headphones a little hot or back?
Yeah.
Checking 1, 2.
Yeah, it's the touchy. You can hear me okay, right?
I can hear you.
It's a touchy.
The
turn it just a tiny bit and change it.
Mean Joe has very hard hearing, and he turns it up pretty high on those headphones, so that's why your mic may sound
gotcha.
But anyway.
Yeah, good morning. It's Friday again. You know, you were out last Friday, and LB filled in for you.
Yeah, how did that go?
Went good. Well, from what I can remember.
Yeah, I didn't pay much to do it.
No, right. So, yeah, well, you know, we do this show every Friday morning. It's been a little over 2 years now.
Isn't that amazing?
You know, right around Mother's Day, around June-ish, when you guys, 2 years ago.
I'm halfway through my 4-year degree here.
Ah, cool. Yeah, your honorary degree.
My honorary degree.
Okay, I'm a little slow this morning, sorry. But, yeah, I mean, so we do this show every Friday morning from 8 to 9. We call it Bulletproof Estate Planning. It is designed to be an interactive show here on the new talk radio at WDXE. And so if you want to talk or ask a question or share an experience and just anything, feel free to call in. The number's 931-766-9393.
That's perfect. Yes,
I always have to look at the number behind you because I sometimes it's 762 and I can't remember.
Checking to make sure that we are on where we're supposed to be on, and we should be. All the buttons are right. Yeah, there we are. All right, very, very good. And let's see. You've had one of your seminars since we talked?
I had one in November, the 24th or something like that.
Yeah.
Up in Franklin. And the next one we're gonna, we do them about every other month now. And so the next one is going to be second half of January. We decided to keep it after all the holidays, everything's settling down, everybody getting back to the routine. So it's actually January the 22nd, I believe. That's a Saturday. I don't have a calendar in front of me. I'm pretty sure that's what it is.
Yeah.
And that's going to be in Pulaski at the Star Theater.
Yeah.
So that, I used to say that's right next to my office, but I can't say that anymore. And the Star Theater certainly didn't move.
Yeah.
So that means I did or will.
Yeah.
And that's true. My office is relocating. And I'm but don't panic. I'm going 2 blocks away. Actually, if you're on the square in Pulaski, the courthouse is in the middle of the square.
Yeah, absolutely.
So if I could see through the courthouse, I could see where I'm going to.
So
okay. I'm on First Street, so I'm moving to the other corner of the square on Third Street. So it's 1 block off the square. So I'll still be there, but it actually was a building that the State Farm Insurance, Tommy Harrison, was in for 30 years almost.
Yeah,
he was in there.
I think I know the building.
Yeah, he retired, and him and I got talking, and it just worked out, and we moved on it, and as of, back around November 20th, we closed the deal. So we're shooting for being in operation over there around January the 1st. So over the holidays, and we don't have a lot to move. He was set up as an insurance agent, so he had desks and offices in a lot of the offices.
Sure. In
the rooms in the house, because it's a house.
Yeah.
It's a house. And anyway, so there won't be much to move, but we'll get to. I haven't got to it yet. I haven't been able to really think about it. But as the holidays come closer and in the aftermath, there'll be some time to do that. So
absolutely.
I'll have some muscle and manpower with me. My boys will be around, and we'll get some people to help us carry what we do have to carry over. But we have seriously outgrown the space we're in. And it was something that I'd sold to the theater some years ago because I always made a commitment to them that if they ever needed that for their grand project of rebuilding the whole thing someday,
sure,
that I would. And they had a lot of engineering studies done a little while back, and they included that building in the footprint of what they were trying to do. So I sold it to them back in 2020, I think 2019, and I've just been leasing it. So I wanted to have something for my own because the grand plan is my daughter, when she gets out of law school, she's going to come back. She's coming back from Florida this spring. She's moving back, and she'll be in law school, and she's going to come in and work with me, and that'd be great.
Yeah.
And so I thought, I need something of my own, and it just kind of became available. I wasn't really looking at the time, and there's some of the best things that can happen. It just popped up, and it was a perfect fit. So anyway. So.
Works out good.
Yeah, but I mean, we're still right there. We're just not right on the square anymore.
Yeah.
Which is okay. So anyway, you know, one thing I wanted to talk about this morning a little bit was, first of all, I like to tell folks this time of year that, you know, a lot of families visiting. It's a good time to talk about the kind of stuff that we talk about on this show.
Yeah,
estate
absolutely.
planning. It doesn't, you know, the conversation does not have to be a morbid conversation about death and mortality. Nothing like, but it should be something. And I find that family members usually report that they're very receptive to, you know, like say take a couple parents, they're planning to do some
Yeah.
planning or did some planning.
Yeah.
And they want to talk about the family about what they did, why they did it, you know,
Yeah.
that sort of thing. Those conversations go pretty well. I mean, we don't have to
Yeah.
talk, it doesn't have to be a real wet blanket conversation about
Right.
death. I mean, we all know that's happening, but it just, you know, if you explain what you're doing, and especially why you're doing it, and how it's to the benefit of those
Yeah.
folks, or vice versa, if you're the child and want your parents to do it. We see it happen all the time. People come to a seminar, it's parents, and the next thing you know, we're talking to their children, their married children, or vice versa. That some adult children come to the seminar, and next thing you know, we're talking to their parents. So that happens quite a bit. So
Yeah.
it's a good time simply because everybody's around. It's a season of love and all that, and that's, you know, when you do this kind of planning, you're doing it for them.
Yeah.
For the most part. So
The reasons for doing a trust it is kind of important for not only you to understand, but maybe those that you are doing the trust for to understand.
that's right. That's right. Because they may not, you know.
yeah.
But when you let them know that you're doing this to preserve assets, so that
Yeah.
they can be transferred to your successive generation, like your children.
Yeah. So when someone begins to think about it, you know, I would think that first of all they'd think about their purpose and goals and even having a trust. And so I ran across a little article here that things to consider, and I thought, well, I'll ask you about some of this stuff because
So you've been preparing.
I prepared a little bit. So we've talked about avoiding probate, protecting assets, supporting children, and then one said reducing taxes. These are reasons for having a trust. And reducing taxes, I haven't thought about a lot.
Well, it doesn't. Okay. Well, I mean, did you have anything specific about that?
No, it just says purpose and goals, and when you're thinking about having a trust, things are things you might want to consider. Or why are you having the trust? And so I was looking at this, and in parentheses it says avoidable. Is it to avoid probate, or is it to protect assets? Is it to support children, or is it to reduce taxes, or all of the above? And I thought, well, my goodness, it does a lot of those things.
It does. And one of the things that comes to mind when you talk about that is, and I'm not a tax attorney. I have an understanding of it pretty well, especially around the trusts and stuff. But
Sure.
I'm a little bit out of my lane, so I don't give tax advice. But I
Well,
can
taxes on brain this time of year, you know.
yeah, that's right. That's exactly right. And you know what? Let me start off with this, and that is when you do the kind of trust we do, the revocable living trust or the asset protection trust, which is mostly what I do, other than some of the special needs and charitable interest trusts. But these trusts are what the IRS calls grantor trusts.
Okay.
Now, grantor is the maker of the trust. There's actually three terms for the grantor. I don't use grantor. IRS does. But there's the grantor, the trustor, and the settlor. And all those people are those synonymous names for the maker of the trust.
Right.
I use the word trustor and trust because it's a trust, right? And the trust maker is the trustor. Trustor, trustee, and beneficiary. Or grantor, trustee, and beneficiary. So the IRS says these are called grantor trusts.
Yes.
And what that means under the IRS language is they deem them to be tax neutral. Now, a tax neutral to the IRS means if you have, let's say, the day before you make a trust, you've got some property and it's earning income. You know, just put it in your wheelhouse and say you got some real estate and you're renting it.
Yeah.
That's so you got rental income, right?
Yeah.
So before you put it in the trust, you fill out your 1040 tax return every April 15th and report the income, the
Right.
rental income, and pay whatever you have to pay, right?
Right.
If you put it into a trust and then the next April 15th you're filling it out,
Yeah.
you do the exact same thing you did before you put it in the trust, because the grantor trust means any income generated by property in the trust belongs to the grantor.
Okay.
And what they're saying is you're not going to get any benefit or deficit by putting property into the trust if it's generating income. To us, it's tax neutral. It's your income, and so next year your property's been in the trust all this year. It's earned all the same rental income. Let's say nothing's changed. You still report it on your 1040 individual form. You don't file a tax
Interesting.
return for the trust. We never want to do that. It's a much higher rate and stuff. Now there are some tax avoidance techniques that I don't really do. where you can put property in and reduce taxes on the property, but you have to really just completely sever yourself from all ownership of it and stuff. But so the grantor trust says, you know, whatever you're doing now is the exact same thing you're going to do after you put it into the trust.
Okay.
It's still your income. We still want you to report it and pay the income tax on it.
Okay.
That's what tax neutral means to them. So there's no reduction in taxes, but there's no deficit in taxes because it's in a trust. It is completely seamless to the IRS.
Right.
Now, the big tax that comes to mind that putting property in a trust can help with is capital gain. Okay, so what happens when you capital gains tax? Let's just review that. Since we're early in the hour, you know, there's a tax. It's called capital gain tax.
Yes.
And the tax is on a capital gain. So what does that mean? We'll use real estate because that's an easy one to.
Yeah.
You can even chime in on that because you see it all the time.
Yep.
So let's just say your parents buy a house, and I like to use nice, easy numbers on the radio so we don't have to think too hard. So they buy a house for $100,000.
Yeah.
Not realistic now, but
Yeah.
20 years ago, not too out of reach. They buy a house for $100,000. That is their tax basis. Okay. So, let's say 20 years later, the house is worth $200,000.
Yep.
And the parents, now we're talking about the people that bought it,
Yep.
decide to sell it.
Yep.
When they sell it, there's a capital gain. That the formula for the capital gain is the amount of money over the tax basis is the gain.
Right.
So far, I mean, it's pretty straightforward.
Yep.
So if your tax basis is $100,000, what you paid for it, and you sell it to John Q. Public and get for $200,000, you have a $100,000 capital gain. Now, there's a thing called a capital gain tax. Now, it doesn't mean just because you have the gain doesn't necessarily mean you owe the tax. At least you don't owe the tax yet.
Yeah.
So you got a $100,000 gain if you realize the gain. Now, realize means keep the money.
Yeah.
Actually, it means you still have the money 180 days later, 6 months. Okay, so if let's say 6 months go by and you just banked it, okay, because you decide, you know, screw it, I'm going to rent an apartment.
Yeah.
Something like that. Now you have a $100,000 capital gain that has been realized. Now the capital gain tax is due on that.
Yeah.
Okay. So, and that is typically, I mean, it can be as low as 18%, but it can be as high as 40. Usually comes in around the 28% range, I think. I'm not the tax person, know how that figures. But you fill out there's a schedule in your tax return. I forget the number, but it's exactly that, the capital gains tax schedule.
Right.
Now, what you can do if you don't realize the gain, meaning you don't keep the money, you have the opportunity to do a 1031 exchange, which is roll that over into another piece of property that's of equal value, meaning the $200,000 that you sold it for, or more. Okay?
Right.
When you do that, you kick the can down the road on the capital gains. You don't have to pay it.
Right.
And so, I know I'm not going to get into it any deeper than that because that original tax basis kind of follows that.
Right.
It doesn't. So, but you know, so that's if the owners of the, you know, if you're the owner of the house and you buy it and 20 years later you sell it.
Yeah.
There you get this tax. Now, let's say the same owners bought the house for $100,000 20 years ago, and they somewhere along the line they put it into their trust, either a revocable living trust or the asset protection trust. Really, almost any trust. So you put it in there, and they say in the trust, at our death, this house goes to our son. Okay?
Yeah.
Keep it simple. Now? Let me do one more thing before we put it in trust. Let's say before we put it in trust, the parents say, you know what, I'm worried about going into long-term care, dear, and I'm afraid if we get sick and we have to go to long-term care, that the long-term care is going to take our house or get our house.
Yes.
So let's give it to Johnny, our son, now, during life, an intra vivos transfer during life, okay?
Right.
So they say, okay, let's do that. Let's write up a deed and say, you know, for $10, love and affection and other good and valuable consideration, we give this house to our son. In other words, at no cost.
Right.
You gift it to them. Now, let's talk about the effect on the child. When you gift a piece of property like that during life to a child,
Yep.
let's say this house is now worth $200,000 because it's 20 years after we bought it.
Yep.
You've just handed the child your tax basis, which is $100,000. And the reason the tax basis is the same is because what you've done, there is not a bargain for sale or exchange. Therefore, there's no way to calculate a new tax basis.
Uh-huh.
And so when your son gets it, he gets it. When you gift it to him, his tax basis is $100,000. So if he would turn around the very next day and sell that piece of property, you would have handed him a $100,000 capital gain.
Yeah.
That may be or maybe not taxed, depending on what he does. Okay?
Right.
So that's a real detriment to giving away property during life, in my opinion.
Yeah.
I've had some people that unfortunately thought that process through and have deeded away, you know, a $1 or $2 or $3 million farm, and you're talking about that was bought 50, 60 years ago. Tax basis is, you know, nothing. $30,000 now it's $3 million. You know.
Yeah.
So the capital gain there is horrific. Now, so that's what happens if you sell it yourself or you give it away during life. So let's say we put it in trust, and we say in the trust, at our death, or the second death of a couple, this piece of property goes to Johnny, our son.
Yeah.
Now, then we fast forward to the second death, the trust is being administered, the trustee of the trust says, okay, this house goes to young Johnny, so we write up a deed that says, so-and-so trustee of the parents' trust, quit claim to Johnny, our son.
Yeah.
Go hand him the deed, he's now the proud owner of it.
Yeah.
The day he deeded that property, his tax basis experiences what we call a step up in basis.
Right.
Now they're a little more complicated because there's a little bit of action on that at the first death and then at the second death. But essentially at the second death, he gets a step up in basis. And what that means is his tax basis, now remember the parents' tax basis was 100.
That's right.
His tax basis is now the fair market value the day of death.
That's right.
And now it's $200,000, right?
Right.
So his tax basis is $200,000. So what's the effect of that? Well, if he turns around and sells it the very next day, he gets $200,000 for it. No gain.
No gain.
No gain, no capital tax,
Right.
capital gains tax. If he keeps it for 20 years and it goes to $300,000 and sells it, he does have a capital gain, but his gain started from the step-up value.
The higher step-up.
So he only has a $100,000 gain after 20 years of owning it, and it goes to three, right?
Right.
He has his own gain going on, so it starts all over again, right?
Right.
And so that's the biggest tax advantage that I can see, because there's really not, I don't know of any income tax advantages, because, you know, when you give property to your children, and it's worth saying that, you know, we're talking about real estate, but let's just say you had an Edward Jones account, had a bunch of stock in it.
Right.
You can say you bought Home Depot stock or cannabis stock or something, I don't know. You had stock, and when you bought it, it was $10 a share, and now it's $50 a share.
Right.
And you say, I leave all my stocks in the Edward Jones account or Raymond James or whatever to Johnny. Those also receive a step up in basis. You know, not just real estate. All property like that.
Yeah.
Gold would be a good one, because gold would be a super one for avoiding capital gains, because if you bought it 5 years ago, now it's at $5,000 or $4,000 an ounce. You know, it's quite a bit of change. So that's a tremendous advantage to your heirs, to put property in the trust and leave it to them and get that step up in basis. That's a big advantage to them. So now, as far as regular tax, like income tax, you know, that's kind of a double-sided coin or double-sided sword. There is no, let's say you have $100,000 of cash in the bank.
Yeah.
It's not in any form other than just deposit in the bank. Then you leave that to your child. Well, there is no inheritance tax, okay? So there's no tax on that because you inherit it.
Right.
And we don't have an estate tax. There's a federal estate tax, but it's up to $15 million. And it'll change here after the first of the year. But so essentially we don't have an estate tax either. But when you leave that $100,000 to Johnny, that is unearned income.
Yeah.
It's like he found a bag of money on the sidewalk and reported it on his tax return. You know, unearned. Because you have earned income, you got unearned income, right?
Yep.
That is purely unearned income. And that is going to trigger an income tax event, because young Johnny's going to have $100,000 of unearned income more in this tax year now because of what he received from the parents. It has nothing to do with the fact that he inherited or it's passing by death to him. It has everything to do with him having $100,000 of income in this calendar year now. That he has to report as income and get taxed on. Now, there's things you can do when that happens. You can maybe split it or be in 1 year and then the next, or, you know, I have to always tell people to talk to their tax guy, and there's ways they can mitigate it or defer it. Some things you can do about that, but there's no, I mean, that, and it's not a tax because you inherited it. It's not an inheritance tax. It is actually an income event.
Yeah.
Like I said, it's the exact same effect would be if you won the lottery and they handed you $100,000 cash.
Yeah.
You know, so those are the tax consequences that I'm aware of. Okay. And as far as reducing taxes, I'm not sure. I know they say that, but there's lots of kinds of trusts out there. I only really deal with the kind of trust that people want to preserve their property, pass on to their heirs and stuff like that. That's not the only thing trusts do. There are some trusts that, you know, I often say you don't have to be a rich person to do a trust, but there are some trusts that wealthy people do where they put property into it. They pretty much divorce themselves of all ownership. And when you do that, the taxes on that piece of property are reduced, but you don't own it either. You know what I mean? And I don't even do those, so I'm way out of my lane talking about them, but I know they exist. I know they exist. There's
Which
some,
sounds bizarre a little bit, but
well, it's,
because you'd think that they would still have some type of control of that property if they
well,
just
I mean,
completely divorce themselves from ownership of it.
it's like our asset protection trust. I mean, we maintain control, but we pretty much give up access to the principal, which isn't that bad. It sounds bad, but it's not really bad.
Right.
But you know that if you don't own it, they can't tax you on it.
Yeah, yeah,
You ever hear the concept? I want to own nothing, but control everything.
yeah.
That's the concept. If you don't own it, they can't tax you.
Well, that kind of brings us to the next little step in my.
Does that help? Does that answer your question a little
Yeah,
bit?
it does. I was it just think okay, well there's
Good, because
there's
it was a 20-minute answer.
yeah, it was pretty good. It's pretty good. So we think about why we have one and what's the purpose of that, but then you got to think about what goes in it and what goes in the trust, all the assets, and you've got real estate, bank accounts, investments, business interest, life insurance.
Well, life insurance, technically not. Because let's look at life insurance. Let's say there's two kinds. There's term,
Yeah.
then there's like some kind of whole,
Yeah.
which goes by a couple different names, whole life insurance, universal. Term insurance, you have no ownership.
Yeah.
I mean, term life insurance is pretty cheap.
Yeah.
You get a couple $1 million policy for $50 to $100 a year, depending on your age and your health, right? And if you live long enough, all those you don't have to give nothing. All those premiums are just down the drain, right?
Right.
They're not down the drain, but they're spent.
Right.
Theoretically, insurance companies betting that you will live long enough so that it just becomes it goes away. You live longer than the term,
Right.
And you're betting that you pass away before the term,
Yeah.
and so that your death benefit goes to somebody. So since you own nothing, there's nothing to put in the trust. You don't own anything. You may say, I got a $3 million insurance policy. No, you don't. You have a death benefit of $3 million that goes to somebody else. It's not yours, and you have to die for somebody else to get it. So you have absolutely no ownership in a term life insurance policy, so you cannot put it in the trust. You can only put stuff in the trust that you own. There's no ownership there.
But now that's considering if it is strictly a term policy.
That's right. Now, if it's whole or universal, those are policies where you have some ownership.
Yeah.
They call it cash surrender value or something like that. Now, it's possible to put those in.
Which a lot of people have.
Yeah.
Those type of life insurance policies.
I would say it'd be interesting to see the statistics on that because whole life insurance is considerably more expensive.
It is.
Very much so.
But they were sold as not only life insurance but investments.
That's true. Now you have the cash value. Now typically we don't put those in, but we could.
Yeah.
And it's usually we have to evaluate that whether it's a good thing to do or not.
Yeah.
In other words, if you're trying to get qualified for care in what we call a crisis case,
Yeah.
you would be required, and let's say you didn't have any kind of planning, you would be required to cash that out and use that money for your cost of care.
Yeah.
So because you do have ownership, it's an asset. But
Right.
typically, if you do the asset protection trust ahead of time, we don't want to put that in there because you have to cash it out to get the cash value. Now you can put it in, and there are some life insurance trusts where you do that. But it's not typically what we do, but it could be put in because you do have some ownership, and if you have some ownership, you can put it in. But your ownership changes all the time.
Okay. All right. Well, we got a call coming in.
I didn't hear a ring.
I had the ringer turned off, and I may have missed one. Hey, good morning.
Yeah, the life insurance you're talking about, not term, a lot of people invested in it 35 or 40 years ago, and this may not be true today, but insurance companies would let you borrow, ours would, up to 80% if you were given a diagnosis of 6 months to live. So people have taken out in the past older people because of that, which may not be true anymore.
Yeah.
But Mr. Pierchoski mentioned something last week he may not want to go into this week. It was about it has to do with payout on death that's not supposed to be legal, but according to AI, it probably is. But I went to Tennessee, the Tennessee side, and I can't find where it's been paid passed, but it was last discussed in February. But it did bring up some interesting things. I thought it said he had said something about he wasn't sure all the reasons it was taking so long because somebody would still need a trust. But evidently it operates outside the will. I don't know if it operates outside a trust, but it said one of the issues was Medicaid. They could have slowed down if it didn't pass because it said that they weren't sure how whether or not this would be considered by Medicaid as income if you had a pay on death. There were other issues like creditors, whether or not creditors could get to it if you did it. I just wanted to he wanted to discuss there, maybe later, why that might be some of the issues with if it was. And they also included cars and things like that as opposed to just real estate.
Okay.
And that may not even be relevant today.
Okay, all right, thank you. Yeah, I missed last week, but so I don't know.
Well, let's talk about the first part, which was you can borrow 80% on
Yeah,
a life insurance. Now, I've never heard such a thing.
I think
I think when you have equity in a life insurance policy, you can borrow against the equity.
yeah,
So how much percentage you get, I find it hard to believe that a bank would loan you 80% of your equity if you only had 6 months to live.
yeah,
I mean, they would certainly want to know what your security and your capital or your collateral is to do that because they don't, that's a sure bet you're not going to be around to pay that off probably. But that may or may not be true. I don't know. I don't know the advantage of that, but so I can't answer that because I just don't know. It's an insurance thing. I'm sure every policy that discusses in a whole life, every policy will discuss what you can and cannot do with the equity you have in there. So if you want to do something like that, you got to read your policy or have somebody interpret it for you.
yeah, that's
Now,
true.
as far as last week, I think what we're talking about, and using a lot of mixed terms like doing with income and Medicaid, but I did talk about the fact that some states you can put on a deed. Okay, this will be right down your wheelhouse. You can put on a deed. Well, let me back up a little bit. If you have a bank account, you can make your bank account pay on death. Okay, which is like making a beneficiary. So if I say I have money in the bank and I make my daughter the POD, the pay on death person, at my death, that bank will pay whatever's in that bank account to her.
Okay.
It's like a beneficiary thing.
Okay.
Now, the question is, some states have something similar for real estate.
Yeah.
It's called transfer on death, TOD.
Okay.
And some states have a law that says if you draft your deed, you can put in there that this deed transfers to my son at my death. Okay. And it works the same way. At death, he owns the property. And it doesn't even require, well, let me put it, for reasons I'm going to talk about in just 30 seconds, it may or may not require a new deed to do that. Now, I think it does require a new deed. But, so the question is do we have that in Tennessee? The answer is no, we do not. But what I talked about last week was that bill has been proposed to the legislature to make transfer on death.
Okay.
And I read it. It creates a whole new section of code. There's a chapter that doesn't exist right now under the real estate title, and it talks about this transfer on death. It talks about the language you got to do. And it was very interesting too. There was a lot of requirements have to be met to put this in.
Yes.
And I won't go into it because it got stalled in the legislature, and it has not yet been enacted into law. And I would like it to be, but it hasn't been there yet. So do we have transfer on death? Kind of almost, but no.
Yes.
So I think it will be enacted. I don't know what the holdup is. I'm not part of the legislature. I don't know why it hadn't been voted on and put into law. But when it does, we'll be able to do that with real estate, transferred on death. And that is a probate avoidance technique. Now, then she also mentioned a question like, if we do that, is it going to affect, will it be considered countable by Medicaid? Will they be able to get after the property? Okay, now, because it hasn't been enacted yet, I don't have the absolute answer, but I can tell you what I think would it be from a legal analysis. And the answer would be yes, that still could fall under the state recovery. And the reason I say that is because what we have now with a husband and wife is right of survivorship. Okay? Now, if you're husband and wife, you own your home and you own it with what we call tenants by the entirety with a right of survivorship. What that means, if one of you pass away, all ownership instantly vests with the survivor at the time of death. You don't go to court and go through probate. It doesn't pass by probate. It doesn't pass by contract. doesn't pass by beneficiary, it passes by the rules of right of survivorship, okay?
Okay.
Now, if that person was in long-term care for a few years and then died, that's what, there was a court case, it was a Smith case, it was some years ago here in Tennessee, that said that is an indicia of ownership at death. And if you have any indicia of ownership at death, it's subject to estate recovery. And so even right of survivorship, even at death, you have this ownership in that. So if a person's in care and they rack up a bill, TennCare can put a lien on that property for the cost of their care.
Sure.
Now, the transfer on death, if the law stays consistent, will be the same way. In other words, if you pass away and you have a deed that says transfer on death, I mean, you wouldn't do that with a spouse because you automatically have right of survivorship.
Right.
But you could do it with a non-spouse, a child or something.
Yeah.
It does transfer that person, but I'm sure if the court wanted analysis, they'd use the same logic and say that makes it subject to the estate recovery because you'd have ownership at the time of death.
Okay.
It's just transferring to someone else. It's not like it goes away. You had it at death, okay? Now,
Okay.
and you had it during life, meaning that's why they can come after it in estate recovery. You know, you have that asset. And so if we ever get it passed, I think that's the way it ought to be treated, as something. Now, there's a way to avoid them getting it. That's not kind of the subject of the question, but when you have a right of survivorship, there's a way to keep it out of the estate recovery program.
Okay.
And so the exact same logic that we use to keep it out of the estate recovery on right of survivorship will be the exact same strategy that we use to keep it out of estate recovery on transfer of death, if it ever comes to pass.
I see. Okay.
So, I mean, there's a lot to it. I think it would be great if they pass it. A lot of states have it. Don't know why we don't, but I mean, we're apparently trying to get there. And it's interesting because a lot of requirements, I'm trying to remember some of them. It was back in the summer, I think, when I was looking into it. She said the last time it was discussed was in February. That might be about right, but
Yeah.
it seems like when I was looking at it, it kind of stalled out a few months before that.
Yeah.
So, again, I guess if I could find some time to look into it to see what the holdup is. I don't know. I might call Clay Doggett or somebody and ask him if he knows anything about why that's kind of hanging out there. I don't know why it's not been voted on. Usually those things mean there's a problem somewhere, or they're still hashing over the terms and conditions of it.
Yeah.
But when they do stuff like that, and so many other states have it, I did notice that they just really use a lot of the same legislative language.
Yeah.
They don't really reinvent the wheel.
Yeah.
They kind of do it somewhere else that has similar laws.
Interesting stuff, man.
But that'll be an advantage. I can see some uses for transfer on death.
Yeah.
Because, the right of survivorship is only husband and wife.
Yeah. Yeah.
You can have right of survivorship with a non-spouse, but you got to have an actual deed that says the word right of survivorship where you don't
That's
get
correct.
it with a non-spouse. But if you want property transferred to somebody other than a spouse, the TOD, transfer on death, would be a pretty nifty instrument. I mean, you wouldn't have to do much.
Very good.
So
It would replace a trust, though, right?
No, it wouldn't replace a trust, but if here's the difference between that and our asset protection trust.
Yes.
If you have, let's magically fast forward and say legislature passes it. Now we have transfer on death, right? And so you put in there, transfer on death to my son.
Yeah.
Now let me ask you a question. I want you to think about this before you answer. When you say when a deed says I'm going to transfer it to my son on death, does that or does that not presuppose I have that piece of property at my death?
That does.
It does, because I'm transferred to, I'm gone,
That's right.
right?
You can't transfer something
So
you don't
what
know.
could happen during my life would make it so I wouldn't have that piece of property?
Well, you could sell it.
Well, I mean, what could happen that involuntarily that could make me not have that property? I mean, some kind of creditor, long-term care.
Yeah.
So if you go into long-term care and it's a countable asset, which it would be,
Yeah.
because if it's your primary residence,
There
it
you go.
enjoys a little something different. You may not have it at death to give to that child.
So I
there's
trust it.
transfer on death, it couldn't replace the trust because it gives no protection. It just moves it at your death.
gotcha.
Like a will.
Yeah.
When you say a will, I leave everything to my kids, it presupposes you have everything.
Yeah.
But because that's a testamentary instrument, so is transfer on death. It's a testamentary instrument that happens at death. So what the asset protection trust does, it looks at the period of you, the maker of the trust, during your lifetime.
Yes.
And it protects you from your creditors during your lifetime. And the creditor everybody's worried about is long-term care.
That's true.
And when I say creditor, I get this all the time. When I get creditor, people say, well, I don't know anybody anything. That's not what I'm talking about. That is not a creditor. Even if you had a car loan or a mortgage, they are not a creditor. Why are they not a creditor? Because you have a contract that says what your specific performance is. Let's take a mortgage.
Yeah.
You have a mortgage that says if you pay us $2,000 a month for the next 30 years,
Yeah.
and we'll loan you the money.
Right.
And at the end of 30 years, you own the house. So all through that 30 years, are they a creditor looming over your head? No, because as long as you are specifically performing under the contract and your duty is to pay, it's a contractual thing.
Yeah.
They can't come in and just say, you're not a creditor until you stop paying them.
Right.
They file an action in court and get a judgment against you. Now they're a creditor. See? So if you just because you have a payment plan with somebody,
Yeah.
that's a contract. You're bound by contract. And it doesn't, again, you can put that property in the trust, but you're not defeating them. In other words, you can't say, well, I got a mortgage on a house, I'm going to put it in an asset protection trust, and I'm going to tell the bank to go pack sand. No, you can't.
Can't
Defeat an existing creditor because they still have their remedies at law by contract. So if you stop paying, they still maintain their remedies of law of foreclosure and doing what they need to do. You have to carve them out as an existing creditor. It's self-serving to try to defeat an existing creditor.
Yeah.
Future creditors are open game for protection
Yeah.
because they don't exist yet.
Yeah.
But when they exist, they can't come after anything in the trust we have. But if you've already got a creditor, you can't. It's self-serving to just. I mean, let's look at it. If you could do that, if you just have a trust, put everything you own in a trust, and tell everybody you owe money to go pack sand. I mean, first of all, nobody would ever be a creditor because it's too easy to avoid them. So it's self-serving to do that. The law will not allow it. So, but future creditors, that's why pre-planning is important. Let's do it now before we have some kind of reason to think something's going to happen.
Yeah.
I forget how I got off on that tangent, but it's a contractual relationship.
Sure.
When you
Okay.
do that. So property can pass at death a couple ways.
Yeah.
By contract, which is that, by right of survivorship, which is a common law action, by beneficiary-driven instrument, where it's another contractual way where you say, I have a contract that says if I pass away, this goes to my kids.
Yeah. And a trust now, a trust has beneficiaries.
That's right.
Okay. Well, let's talk about that for a second because I got questions.
That's the next question. Okay.
That's the next question on my list, which works out good.
Hope we don't have too many more to list.
These are things to consider that when you're doing, and these I know for a fact that you've covered this before in our conversations, but it kind of clarifies it a little bit because these are things to consider. Who are the beneficiaries? How and when do I want them to receive their benefits? Okay. Do I want them all at once? Do I want staggered over time? Are there only certain purposes that they can have this benefit for? All these things you can do with a trust.
I'm trying to reach over there and click the button that says yes to all.
Yes, 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 and yes.
I mean, the answer is yes. With the trust, remember I often say you're writing the rule book.
Yeah.
So if you have a unique situation, and I have a kid that's got this problem,
Yeah.
and so in order to protect him from himself, I guess let's call it,
Yeah.
I want him to get 2.5% at my death. I want him to get 15.17% at 5 years later.
Yeah.
And then I want him to do, and he's just bizarre as you want, and come up with all these terms and conditions, and the trust will enforce that.
Yeah.
That would be enforced.
But you would assume you'd have logical reasons for doing what
That's
you're doing.
right. I mean, let's take some things that make sense.
Yeah.
I often use having an adult child that's got a drug addiction. Now, I use that for two reasons.
Yeah.
One, I see it a lot.
Yeah.
And two, those of us, or those of you that are listening to have children, but they're not drug addicted, it's an easy thing to kind of relate to. You
Yeah.
see why you wouldn't want to leave an inheritance to a child like that.
Sure.
You know what I mean?
Sure.
But you can insert your own problem with your kid. And if you call in and say, hey, I've got kids and they're all pristine, lily white, none of them have any problems, I would say, God bless you, you're the only one.
Yes.
And good, that's great. I wish it was that way for mine. But you just insert the problem you're worried about when I talk about drug addiction. The drug addiction is a very real thing. And in all those years I did criminal defense work, I did a lot of drug cases, and it's a real thing. When people are addicted to drugs, I mean, they have little choice in what they do. It's that strong.
It has a control over them.
Some of those drugs are just ridiculously addictive, and it just controls.
Yes.
Something grabs your brain cortex and doesn't let go. But anyway, if you have a drug addicted child, you might say, well, if I leave him, let's just say he's going to inherit $100,000. Well, if I leave him $100,000, I could very easily be the instrument of his destruction because I've just now removed the impediment of price purchasing of the things for the bad habit, right?
Right.
And they're probably going to overindulge, and then they might kill them.
Right.
But I don't want to, like, what's the alternative on the other end of the scale is just disinherit them.
Yeah.
And you kind of don't want to do that because, you know, if you're, like scriptures want us to be, you love the sinner but not the sin, right?
And you care for them.
Yeah, that's right. They're your kid. You want to care for them.
Yeah.
Like I said, you don't care for what they're doing, but you want all the help you can give. So I might want to let them have this money if they want to rehabilitate or something. But you know, I don't want it spent on this bad habit. So what we can do is we can say, okay, I'm going to leave you this $100,000, but I'm going to put your sister or your brother or somebody else or my brother or my sister in charge of the money. And they're going to, when they meter it out to you, they're going to give it to you for things like health, education, maintenance, and support.
Right.
But if they have any hint that it's going to be for a drug-related issue, they're going to withhold distribution to you because they can't have it for that. But if you decide to go to rehab, that'll be an okay reason for them to spend your inheritance on rehab, so to make you better. I mean, that's a kind of when and under what circumstances in your question. It could be anything you say, as long as it's something we can relate to your successor trustee that they know what to do.
Yeah, that brings me to the next question.
Okay?
The trustee, the enforcer, the person in charge has to make those decisions.
That's right. And so we put in the trust as much as we can to give them some guidelines.
Yeah. And I see this on here. You put a person in charge, a professional, someone, or a bank, or a trust company. Have you run into that? What is a trust company?
All those are, you're talking about, you have a trustee, like
Who should be the trustee?
you can have a trustee of a trust. During life, it's a lifetime trustee. After death, at your death, it's a successor trustee. But
Yeah.
a trust always has to have a trustee.
Yeah.
And the trustee is the person that controls the property.
Yeah.
Okay. A
Somebody's gotta
successor-
be in charge.
That's right. And you can name your kid, you can name your brother, you can name a person, but you can always name a professional trustee.
Mm-hmm.
That's what those folks are. Banks have trust departments.
Okay.
Almost all of them have a trust department. Not all of them, but a lot of them will act as trustee for things if you know, of course it's a compensated position, they get paid for that.
Yeah.
A trust company, we got one that comes to mind is Cumberland Trust here in Tennessee. They are professional trustees. So if you have a couple that have no children and they need a successor trustee and there's nobody to appoint, I've often had people where they hire a professional trustee to step in.
Well, time out just a minute. What qualifies you to be a professional?
Well, there's some
trustee?
There's some things you can do with the state of Tennessee that may, it's like anything else. I'll be honest with you.
Is that
there's
a
some-
licensed
Yeah,
position?
it's a certification or license position.
Okay, I did not know that.
You have to be. It's kind of a banking thing.
Okay.
You have to know and understand what you're doing.
Sure.
Now that is very common for special needs trusts.
Yeah.
When somebody has special needs trust, so I'm just going to have my son do it. I try to advise against that. I say, special needs trust, those laws change a lot. They're very strict. You're better off with a professional so we don't screw that up.
Yeah.
So,
Interesting.
but I mean, for a regular trustee on trust, it's okay to name a family member.
Sure.
But if you're going to name a family member, or if you're going to name the professional, we got to have terms in the trust to say, okay, here's the problem we're worried about. Here's what we want done to prevent that problem. So if we're going to say, we can't. It's hard to say. Just don't use it for a drug-related issue. That's getting there, but we should be a little more like what we can use it for, stuff like that. And we might want to have terms that say, okay, is this going to be forever for this kid? We might want to say, well, if the trustee says there's been no drug-related activity for a term of 3 years, or 2 years, or 5 years, whatever you want to put in there, then we should have the whole thing just dissolve and be an outright distribution to the child and let him have his inheritance because now the problem we were worried about doesn't exist anymore. And it's okay to give him his money because the whole reason we put it in trust and put a trustee over it is because we were afraid he was going to kill himself with it, or he was a spendthrift and he was going to blow it, or his wife was a gold digger and he was just going to give it to her and she was going to blow it. All kind of problems that you want to, we can have self-exacting terms that terminate the problem.
Yeah.
If the reasons we put in protected it are gone.
Interesting.
So yeah, you're writing the rule book. You can be as creative as you want, and that's what gets enforced.
Okay.
And we do a lot of that because everybody, like I said, if your kids are all great, then you're the only one. And there's reasons to protect their inheritance. So a lot of times I refer to as protect it from themselves.
Yeah.
Now there's other reasons to protect it, or not quite like that, but let me tell you, I probably mentioned this before too. I had a client, it was some years ago. But she came into me, and she was relatively younger, and she wanted to do a trust, and she had some children that were young.
Mm-hmm.
And her story, in a nutshell, was she said, "You know what? I inherited some money from my mom and dad," and she said, "I stupidly blew it. I squandered it all on stupid things. I just spent it. I lived it up. I had parties. I gave it some to friends." And then later on in life, I got married and I had kids, and we wanted to buy a house. We just couldn't scrape up any money to get the house. So we're still renting. And she thinks back and said, if I had not blown my inheritance, and she was very upset with herself, and I get it.
Yeah.
But her goal to do this trust was she had these kids, and she basically said, these children are not doing what I did.
Yeah.
So they're gonna get my inheritance, and I'm gonna make it so they do not make the same mistake that I did. And that was a powerful story.
Yeah.
And that's what we did. We gave it to them. I mean, we put it in trust, and we're gonna control it. Now, if they grow up and they're entrepreneurs and they need money to open their own business, that they'll get some inheritance. You know, if they are get married and need help with the down payment on a new home, they can get their inheritance. You know, if it's a good start or something, it's the inheritance is there to help. If it's like, hey, I want to go on a 6-month cruise and just party for it, can you give me the answer? Is no, you can't have it for that.
Yeah.
Now, but when you do that, you have to use some language to define what the person, because you're gone, what the person who's letting them have the money for, what terms and conditions they can have it under.
Yeah.
And you can be real general or you can be real strict.
Kind of reminded me of an episode of Raymond. You ever watch Raymond?
I don't, but that sounds familiar.
Robert the Big Brother was poor on cash, and he borrowed some money from his brother. And then they found out that right after he borrowed the money, he took off to Las Vegas with it.
You know, that reminds me of another movie. Remember the movie Armageddon?
Armageddon.
With the guy that played Rockhound?
Oh, I don't know
The crazy guy with I forget his name.
Is that the one where they went up and did the...
On the asteroid,
Yes.
they tried to drill into it and split it.
I remember that.
Rockhound, he figured they were going to die because it was a very dangerous mission. So he went out and borrowed like $100,000 at like 40% interest from the shark. And then a couple nights before they show him, just girls are coming over and he's just throwing cash around, something like that. Then on the way back, after they survive and actually split the thing and it missed the earth, they're going back and everybody's thankful. And he says, what about me? I borrowed $100,000 from a loan shark at 40% interest. The one guy beside him goes, well, that sucks. So
you made a big mistake.
Yeah. Hey, we got during the last couple of minutes. I kind of want to ask something. I do something. I do it on another radio show I do out of Nashville. But right around this time of year, I do something called the biblical aspects of estate planning.
Oh wow, that's good.
Now, I just would like to ask if you think that's something appropriate to do on the radio or not. I just here's what I do. I have done this. Is something I did years ago. You go through scriptures, and I'm kind of a staunch Christian. I love to study the Word. And
I'm with you, buddy.
Yeah, and I've been through the word inheritance, or at least the Hebrew, Greek, or Chaldee word for inheritance is mentioned between cover to cover just under 300 times.
Oh wow!
Now I'm not going to go talk about all of those, but I do like to talk about some of this concept that when you talk about inheritance, estate planning, that's what we're trying to talking about.
Right.
This is not a new concept. I mean, lawyers didn't make this up, and this is not something that's an original idea of mine. This comes from the Creator. If you want to research inheritance and look back, and then look back from there, and look back from there, I maintain eventually you're going to get your feet wet crossing the Jordan River, because this concept comes from God Himself.
Yeah.
And it's a little different. You don't own the land. He's kind of saying, hey, this is all. First of all, everything's mine.
That's right.
But I'm going to let you be good stewards of it. You essentially, as far as we're concerned, we own it and use it as long we can use it, and you can pass it down to your children. Yeah. Like I'm going to do. Yeah. And when He gives the promised land and stuff, so I kind of go over stuff like that. But I mean, if you think it's absolutely. Sometimes sometimes public forums don't want to get into specific things.
We're not afraid of that here at all.
Well, if you're not,
I'll quite a bit.
I'll talk about it. Don't mean being offensive, but I mean, it's very interesting. Yeah. Very interesting because it talks about a lot of the stuff we do nowadays. It's surprising that the correlation is there.
Why don't you think about it? I'm not telling you what to do. Why don't you think about preparing that for next Friday?
I mean, I do it every year. I already got it prepared. So I can bring it in. But
that would be awesome.
Okay, we'll talk about it.
That'd be awesome. I would love to say that's a good. We do that. I have a Bible portion of the program every morning.
I see. Oh, great.
Yeah.
Well, listen, we're getting toward the end here, so if you want to talk to me about anything we talk about, it doesn't have to be
Yeah.
you know, what we talked about today, anything estate planning, or you want to
Yeah.
schedule some time with me, just call my office at Pierchoski Estate Law, Pierchoski Elder Law.
Right.
The telephone number is 931-363-7222. 363-7222. That number will stay with me when I move my office.
Yeah.
Or you can go my website, estateplanstand.com, and there
Right.
you can ask a question by email or something like that.
Yeah.
Seminar coming up on January the 22nd, which is a Saturday, 10 o'clock, right at the Star Theater. Will's Trust in the Nursing Home. Not too early to RSVP for that. And finally, the Star Theater, the final performance of Nutcracker, which has been sold out practically every show,
Yeah.
is tonight at 7 o'clock.
Okay.
And I'll be at that one, so.
Oh, well, good deal.
I don't have a
Good deal.
seat, but I'll stand somewhere.
You're
I mean,
gonna be there for it.
I mean, I let other people buy. I buy a ticket, but I'll just stand in the back.
Well, that's a nice little venue there, and they do some really great productions.
Over 60 kids in Nutcracker.
And of course, speaking of that, of course, are you prepared now for Christmas? You got all your Christmas
Not even
done?
close. Not even close. Let's not talk about it. Maybe it'll go away.
It's not going to go away. It's not going to go away. Well, Stan, you'll be with us next Friday, good Lord willing. And again, if you need to get in touch with Stan, it's 931-363-7222. You can also visit the estateplanstand.com.
That's estate plan.
Yeah, estateplanstand.com. Listen, there's a lot to do when you think about doing these trusts, a lot of questions. And I was just thinking about all the different things that you need to be consulted with.
And we'll give you all the guidance
Yeah.
you want.
Yeah, we got just about 20 seconds before
Okay.
that bell rings off, but we appreciate you being here.
Oh, it's always a pleasure. I enjoy doing
And
the
I'm
show.
looking forward to next Friday.
And I often say this, welcome to one of the fastest hours of my week.
Yeah.
You know, when I come here, it's fun. We talk, and next thing you know, I'm looking at the clock. It's 8:59.
Time to go. Time to go. Thank you, buddy.
Perfect. Perfect timing. No